As well, he is well recognized legal luminary in India, and each person in the room is well aware of the hard work you have put up to reach where you presently stand. Thank you for being such an encouraging figure, sir. We look forward to learning from you and having a time of your life. You radiate unmatchable energy, and I hope we all can do equally great and make this day memorable. On this note, we want to hear your words of wisdom. Over to you, sir. Thank you.
Thank you very much. And it's a great honor for me also for invited for this particular program. And I was thinking that this program will go on online. Somewhere I tried my level best to keep it on online, but the request of Chanchal and all of you to come. So I started yesterday night and the late night at 10 o'clock. So I reached early morning today to deliver two lecture to all of you. And also, this is the first challenge. The second challenge, the topic which has been given to me also because I wanted human rights, but human rights has been snatched from me to for the other teachers. So left over with a very difficult. So, as a scholar, you keep on thinking that is important. How challenge is close to you. It's not necessary you have read everything in America. You're equally expert on each aspect, but each occasion offers you a challenge and opportunity both. Either perform or perish. So, so challenge you have to accept and you move on, and you start thinking about the how to address. As a teacher, I feel personally, most important aspect we have to draw a framework while any topic you take how to engage 60 minutes, 90 minutes, and 120 minutes. You have a syllabus before you, and syllabus is there. So one focus we should not miss, the syllabus has to be completed in 30 classes or 40 classes. But if necessary, one or two plus extra minus like a 5 classes one can take also. But that is very important. But when you go with the class, with the content, full content, but still you find if I start speaking in 5-10 minutes, my lecture will be content will be over and I'll compel you, you participate, you encourage, or question answer. So I see that these are the things we have to think about. Same logic I applied in the topic, the first topic which I have for the tribal culture and justice dispensation system. So you all have know the relevant provisions of the Constitution and most important the Article 370 earlier was a little bit, but 371 and then you have Part 5, Schedule 5 and Schedule 6 is very important. Schedule 5 applies for the more the central Indian part and the Pradesh, Madhya Pradesh and other states, whereas the Schedule 6 that becomes very important for the northeastern states, and then we have tribal advisory council, then we have district advisory council that are which has been laid down under the, so that itself gives you a lot of material under the parts schedule 6 and schedule 5 gives you a lot of, and then of course you can add, but that is not required because this has not been applied. You have a PESA 1996, you have Forest Development Act 2006, and then one need Forest Act, and then one more act is there. The three acts are there on that particular area, but these are not very relevant for the topic which we have. But the interesting part, which attracts most of many, curiosity. And I remember when Justice Thakur was the Chief Justice of India, he had a special interest to understand the laws, which customary laws, particularly prevailing in the northeastern states. If you by chance you colleague you have a find in your university or colleges, always you have a colleague. And very interesting, and that's like the elderly person of the village in Mumbai, some of the northeastern states is still civil disputes or criminal disputes. So there's a village hate. So that is a little bit moved from the schedule 6, a customary kind of things which are there, which Gaon Budha, that GOA, and Budha BURRA, that person Gaon Budha means just like in Hindi mein bhi hum kehte hain, to ek elderly person ki बात करते हैं and he decides about the matter. And that is why the cases in Manipur and some of the Nagaland, other places, cases are very less registered in the police station. Judges have very cases to dispose because people trust and they go to the local tribal justice system, which is there. Our tribal justice system can be, when we talk about the tribal justice system or customary justice, so we want to tribal people because we don't use the term indigenous people. They are the actually aboriginals, the tribal people who are Santhal. Now we are very happy that we have a president going to be Santhal. But Santhal are the originals in the Indian context, Santhal, Jorwa tribes. They are the actual, Indians. They have been here for ages. And so they have their own custom, they have their own practices. But question comes what these practices, if it's related with the civil dispute, land allocation or property or something, which doesn't involve, that can be easily suited under the alternative dispute model, Lok Adalat also government says ki Gram Nyayalaya. So Gram Nyayalaya is the 2008 Gram Nyayalaya also I say. So the first Forest Act, Gram Nyayalaya and PESA. These are the three important. Gram Nyayalaya has also given power. So, but these are the legit act is there. In their act is there and then schedule is there. So something beyond schedule, which is also functioning in the name of customary practices. So what we have to understand ki this justice system, what judge as being as the Chief Justice of India, and then he visited many times Indian Law Institute, and always he was very fond of saying we have to try to understand the system and some limitation has to be imposed. So and this has been shared. This may be correct, this may not be correct, but this may have been shared, which we had an opportunity to discuss with some of the colleagues. Even the crimes, sexual assault or harassment or something. The victim family and accused family, they go to the Gaon Budha, and then elderly person, he heard the matter. And then finally he decide on the Sikhi matter with some punishment. What is the punishment? So village feast. So they गांव के लिए पूरा खाना हो गया और कुछ 50,000 compensation or something, and village feast, a matter ends there. So what we see, some of the customary practices which are not according to the law. There are certain section of IPC and CRPC are not applicable, which is there. That is perfectly fine. But some practices and people continues to have faith in a local system. But for the ordinary issues, civil disputes, it's perfectly fine. It can be there and it should be encouraged, because a court procedure is itself very cumbersome and which has to be discussed. But some of the things where it involves serious crimes or the role of the police and role of the court is important and which has to be shifted. Even if I take you to the Convention on Elimination of All Forms of Discrimination against women, so there state has an obligation. What discrimination and this kind of practices is a discriminatory. So I'm taking you to the court also, the Supreme Court of India also. Customary, some of the statutory provisions were in the Nargis Mirza case and other cases also, LIC cases, number of cases. Courts are, these are the provisions are, these acts are arbitrary, discriminatory. It doesn't make, and then court has now when Supreme Court has said, this provision violates the fundamental rights of the women and this has to be struck down. So court has that. So the same way, we have to also see the custody role of the village function, the judicial dispensation system, informal. So you have a formal system, an informal system. But informal judicial system also there, it has a deep root where trust of the people is much higher. That is the question we have. And we all have a common agreement that we can continue some of the areas, but a clear-cut demarcation should be there depending upon the nature crime. So this, because this can be arbitrary, this can be also, this is arbitrary, no doubt why can, this is arbitrary, or sometimes it also, the Gaon Budha also takes a side. It's non personal liking, disliking also places. So other victim has no choice, no control on that, and he has to accept. And most dangerous, which we see everywhere prevalent in the India, in the village system, panchayat. panchayat looks, if you see it in a general common, if you apply that in a common system, you find that panchayat system also holds a great power, excommunication from the society. The moment that बेटा हमें निकाल देंगे गांव से बाहर कर देंगे, so you succumb to the pressure, just imagine कि वो आपको गांव से बाहर कर देंगे, you accept whatever has been rendered. वो कहते हैं चार ये करो, इस लड़की को ऐसे करो, वो करो, whatever they say, and that we see keep on reading in the newspaper. So you can see the impact of the informal system is so huge that cannot be ignored. That has to be so. That is the reason you always raise about the Haryana hate crimes and other things. We feel about, what is there. Now, recently, if you see in just recently concluded panchayat, where they said that a particular community, those who are living in a nearby area, they said that these communities have to be, all the documents have to be verified. And they verified, and they're like to try to trace out their origin from there where they have come and verify whether they have valid documents. And that has created so much fear among the poor people. They all have quietly shifted. They realize some might have documents, some might have not have documents. So they said that unnecessary harassment, थोड़ी सी तो पैसा मिलती है, so we shift. They shifted from that particular place is there. So some kind of but they did not ask for something, but which is the role of the state. Police has to look into that particular part. So our concern, which we'll discuss one way. So how the last point which I have in the general framework is the how the state also hesitate, restrain itself, not interfering in the practice which has been accepted by the society, and that can be understood if we look into the convention in short CEDAW. If you look into the CEDAW, which says states should make an effort to eliminate the customary practices which are heinous customary practices or bad, bad customary practices should be like witch hunting. Number of things are there where customary practices are. So, but now this is there in the convention. Convention said once you have one a fundamental obligation, you have series of obligations. So your main obligation, eliminate discrimination which affects the enjoyment of the human rights of the women, or which woman feels that they are there is a distinction, preference or something. Discrimination is based on ground of economic, social, political and other status. So if that is happening, that has to be eliminated. So broad obligation in the discrimination convention, all aspects which has infringing or which infringing the enjoyment of the human rights of women has to be looked into. There is no need. So sometimes these conventions have come little bit later. So many people, why it has come? Because when we look into if I take you one point which is very important, we discuss constitution. So I'm making it more general, but I'll focus on the other part. So fifth, sixth, and we have a case law also. We discuss about the constitution, और आप में इसमें काफी महिलाएं भी, काफी students भी बैठे हुए हैं यहाँ पर भी. But how many you know that how many women participated in the drafting of constitution? We know that 299 people have participated, more than 200 years participated. How many women participated in drafting of the Indian constitution? So women also play. Some of the women you may be aware also, but total I am asking. So somewhere कहीं ना कहीं ये बात नहीं, नंबर और हम जान रहे हैं, हमें भी नहीं पता होता, ऐसी कोई बात नहीं, लेकिन हम जानते ही नहीं जानते, लेकिन हमने कभी उस एंगल से सोचा है. The problem is not being also, you also have not thought seriously कि क्या हो सकता है. बात वो नहीं, सारी चीजें मैंने शुरू में ही बताई कि हम सारी चीजों को हम समझ नहीं सकते, लेकिन हमारी क्रिटिकल थिंकिंग से हम सोच सकते हैं कि अब उसमें भी हम एक और एंगल भी जा सकते हैं कि कितने वीकर सेक्शन थे, कितने एससी थे, कितने एसटी थे, बहुत सारे एस्पेक्ट को हम दे सकते हैं. वी कैन ऑल्सो एनालाइज कि वेदर द मेंबर्स और 299 they were belonging to a particular or elite class of those who are having everything, whether participations common man participation was there or not. These are the questions also we can be. But total 15 women participated in that particular convention. The constitution said 15, and out of 15, 11 played very important role. in there. Hansa Mehta, Amrit Kaur, Beliani, from Tamil Nadu. There 15 women participated actively, and some of them have contributed hugely. In that context, what I'm saying, so when if you look into the tribal setup or anything or discrimination, so why we need to have a separate convention? Why we need to have, so this like this convention on rights of the child, convention and torture, सारे चीज आपको यूनिवर्सल डिक्लेरेशन में मिल जाते. In one way, universal declaration is a general convention, or even international covenant and civil and political rights is a general convention which encompasses each aspect and most fundamental. So in most fundamental aspect, which in each convention you will find is a focus on the principle of non-discrimination. So arbitrariness or non-discrimination. So human rights instrument may, like even the Constitution 15.1 we have non-discrimination. So like most fundamental principle. So if anything discrimination exists, that has to be removed, and that would if you read any article of any convention, no state should no discrimination on basis of the caste, religion, nationality, political opinion. It goes list goes on number of ways there. So that in itself is sufficient to end the discrimination if it exists in the women also. So that particular provision gives, which has 8 to 9 grounds on the ground. The grounds can be enlarged also. So that grounds can be used, and then discrimination is there, but it has been realized discrimination is so deep rooted, pervasive in this society. It needs to be elaborated for the state. It was उनकी समझ में आवे. आप उन्हें तो भेज है एक non discrimination on the ground of sex, on the ground of religion, but it needs to be elaborated further. कि what are the discrimination, make it more simple, and that is why specific conventions have started coming one by one. Racial discrimination convention, convention against torture, torture हर एक instrument में आपके, लेकिन torture convention, then this women convention, migrant convention, you name. So specific. So we have general human rights convention and also in the specific human rights instrument. However, आप उसको कह सकते हैं. The last point which I have, the contribution of how like in a word played very important role when so one of the members of the Constituent Assembly, that Hansa Mehta, she participated actively in the Constituent Assembly drafting process, and also she participated in the drafting of Universal Declaration of Human Rights. अच्छा, ये मुझे भी नहीं पता था. ऐसे नहीं है कि मैं कुछ बोलता हूँ मुझे भी पता है, मैं भी कन्फेस कर रहा हूँ कि मुझे भी नहीं पता था. This I came to know in the 70 years of the adoption of the Universal Declaration of Human Rights, where it has been, the UN had celebrated her contribution. 70 years मतलब 48 के बाद 2018 में 2018 में UN was celebrating 70 years of the adoption of Universal Declaration of Human Rights, and they acknowledged. So they acknowledge. So by chance, I also looked into it. They acknowledge the contribution of Hansa Mehta. Now, what contribution she has made? She made that the very first article of the Universal Declaration of Human Rights, which said, all men are born free. The initially the word was all men. अभी आपको man नहीं मिलेगा वहाँ पर, all human being. So she has insisted, she has prevailed upon and said, it's like neutral, gender neutral होना चाहिए. All human beings are born free, equal in rights and dignity. So that is the fundamental. So that's her contribution. Some way it has missed from all of us, but this has come there. All right. If I start with the broad theme of this particular discussion, which will go one by one, some legal framework we have looked into, that we have to look into the certain provisions of the Constitution, and most importantly, Schedule 5 and Schedule 6. Where we like to Schedule 6, Schedule 5, it outlines. Schedule 6 is much detailed, larger compared to the Schedule 5, which paragraph 5, paragraph 4, paragraph 5 gives some powers which will discuss in later on. So this is there. So we'll have also an opportunity to identify the cases, some of the important judicial decisions, we'll look into that. But when we look into how far we can sustain the system which is prevailing in this society, The challenge which we have in the today's context, because today the 21st century, I believe the title is Contemporary Challenges 21st Century. Had we this discussion taken place in the 1980 or something? So what is happening? The things have changed hugely. Like, the traditional knowledge, if the justice system, traditional knowledge, like, poor people have no idea. So turmeric was use of names. So all these things were patented one point of time. That patent has been subsequently revoked. But patent was like patented hasn't. Like, even in the Africa and other tribal societies, lot of people, they go there and their things are somebody by inducement or some kind of knowledge they share, and that's gone and they're patented there. So these kinds, so we are living in an era which I call it, and that you all accept, okay, we are no longer living in a closed society. That we are not living in the closed society. We are not a statist which only focuses on the national identity. Whether that we have only, okay, or we are not communitarian, like, those communitarians who believes that nation state is supreme and nation state has all freedom to design their laws, design their everything. But things have hugely changed, and which is impacting all states, like in all aspects and all aspects, even the life of the tribal people are there. I'm sure the things which we discuss, but after 50 years, these things will not be an issue. After 50 years, these things will not be issue, because to society will, education is there, people are like, girls, boys are migrating from one city to other for the job. So a complete new generation will come in the tribal society. So there is a dismemberment of the society is taking place. Their Gaon Budha role is being challenged also. The young boys and girls are coming and they say, we go to the more defined, more like, articulated system where codification is there. So what is there in the Gaon Budha system is the oral practices. What has been said, it has not been codified. एक second ले तो कोई मत. Hello. So what I say, like, it's a that is not longer possible, and particularly one area which has been heavily affected. That is the if globalization. So what we are today, we say that many scholars, and the term which many of you have studied also in a paper when in your LLM days, it's a law and justice in globalizing world. So you have studied a paper also law and justice. So what अब हम उस हिसाब से सारी चीजों को देखते हैं. तो जो भी अगर आज vision आप you see the issues have already, like, change started taking place. Even the tribal justice system is not so strong, which used to be in the north. And it's if I consider, like, if you look into this Santhal Pargana or Jharkhand or even in Chhattisgarh, they are more towards the very small issues is confined to the tribal justice system. In the states which have heavy population of tribal, Odisha, Jharkhand, and Madhya Pradesh, Chhattisgarh, these states, so creation of these states also, particularly Jharkhand and the Chhattisgarh, was largely because of the tribal interest. They said, we have a different from the mainstream people, why should we go? But they are shifting. This problem still remains the tribal, the effective this judicial system based on the formal and non-formal system. It exists more or less in the northeastern states. Rest of the places more civil law, common law, like, our law basically, like, in civil suit, whatever the law we have, both applies to the people and they go for the cut. Even Adivasi or small marriages, family disputes, they look into the, like, that aspect of they focus land distribution and other things they can find to there. But cases, murder, other things they can go to. So these states, we find change has taken place because their interaction is much higher compared to the northeastern states, and which started taking place in the last. So this cosmopolitanism or globalization has brought huge changes. So there is a first reform which can also be possible through migration of people are taking in the tribal places. People are migrating in search of job, in search of education, and people are intermingling. And this society are also going to be being connected. Largely connectivity, communication, connections, all these things were not there. So things are improving. So that here, if we have, so we can continue with the system. We can continue with the system which exists. We can continue with the system with certain reforms. So what we have focused in the beginning is some areas which are inexpensive, and I'll just little bit later I'll discuss on that. And so if we come back, let me start with the what Justice Madan Lakur said, and then some cases I'll discuss. कब तक समय है? 150 there. All right. So Justice Madan Lokur, while addressing in the Jharkhand, somewhere in the Jharkhand, he was addressing a lecture, which I read somewhere, and then lecture he said something which is interesting. And so we have a concern whether we continue with judicial system which exists in this particular area, or we need to modify, or we have to do. There is a more or less in agreement one point. There's codification of the customary. Codification of customary income. So what is happening is so order. It's a going on. There's no structure. So Gaon Bura is a respect, and that can be some kind of fair element has to be introduced. Who has to be? So generally, each person of the society he becomes, whether he's educated or not, that is not ground. But through his wisdom, he participates. He decides. So there is a need to have some kind of element of justice in for justice. I'm not in courtroom justice, but justice has to be like people, those big, both should feel that they have been like justice has been done to me. So that important and codification of that particular. So what Justice Madan Lokur in his lecture, he says the system. So like he has a and he's the system of enforcement of tribal customs is very strong. He says the system of enforcement of tribal customs is very strong in the northeast. So our focus is in another way to Jharkhand. He was delivering this lecture in 2013 in Jharkhand. But when it's so Jharkhand means he said that Jharkhand has already centered or somewhere weakened the tribal system enforcement. But when he so addressing in a Jharkhand, he think about and that time he was the sitting judge of the Supreme Court of India, not retired. So he said the system of enforcement of tribal customs is very strong in the northeast and is constitutionally protected. So how constitutionally protected? Because in the Article 13, paragraph 3. Article 33, paragraph 2 clearly recognize custom as a source of law. So it's a constitutionally protected. So constitutional fifth schedule, sixth schedule are there. And even law customary may Article 13, paragraph 3, which says of the constitution clearly recognize custom as a source of law. Custom as a source of law, international, custom as a source of law, domestically recognized. So under international law में आपको Article 30 of 38 of the ICJ statute talks about the sources of international law and the sources of international law. तो हम legislation कहते हैं, treaties करेगा legislation कहते हैं, customary law कहते हैं, and then precedent भी कहते हैं sources of law, and then opinion of jurists or like scholarly writings. There, the sources so domestically are there. So custom is a source of law which has been also mentioned under the Article 33, paragraph 3. Then he said conventional courts, so traditional courts, हम जिसकी बातें करें, conventional courts, as we understand them, are very often, as we understand them, are very often out of reach for tribals in the northeast conventional regular code, conventional codes are very often out of reach for tribals in the Northeast. And that is another reason why the method of dispensing, जो हमारी topic, why is the method of dispensing justice in accordance with customary law is so popular among the tribals. Let me repeat. So, okay, कह रहे हैं तो एक judge Supreme Court of India is why in the northeastern regions the the informal court system is popular in the there because of the out of reach. ये काफी दूर है आदमी से गांव में भी कितने के पास पैसे होते का. So he also recognizes the conventional code for various reasons. It's like, very difficult to reach, expensive, and other things, regions we will discuss. So he identity, and that is why the popularity of the village court or village system, not according to the Schedule 6, not according, that is like what has been they evolved in the customary, is very popular among the Northeastern. So it's accessibility is major risk. Accessibility. So what we can also look into while change has to be accessibility, affordability, availability. अगर ये चीजों को आप किसी भी जगह लगाते हैं तो ये फिट होता है. Accessibility, availability, and affordability. अब एक्सेसिबल जैसे होता है, अभी हम उसको बहुत यूज किए in the context of pandemic में health. So how you accessibility को understand करते हैं? Accessibility means physical accessibility. पहले अभी हम जैसे कर दिया, अब यहाँ पर आप कहें कि कॉलेजेस में एक्सेसिबिलिटी का एक तरीका है कि हेल्थ सिस्टम में when we accessibility, availability and affordability are very important, which we need to. So when you discuss anything with the environment or anything or any related to the core system, you can apply, and this is the for just like non-discrimination. जैसे नॉन डिस्क्रिमिनेशन की बात होती है, वो एक फंडामेंटल प्रिंसिपल्स, इक्वलिटी की फंडामेंटल, विदाउट गोइंग इनटू द इक्वलिटी और नॉन डिस्क्रिमिनेशन प्रिंसिपल आर वेरी इंपॉर्टेंट फॉर द प्रोटेक्शन ऑफ ह्यूमन राइट्स. आप उसी पर अगर लेक्चर दोगे तो उसको ही काफी एलोबरेट कर सकते हो. अगर वो दोनों चीज ही फॉलो हो गया तो मोर और लेस रेस्ट ऑफ द थिंग्स विल बी टेकन केयर. अगर स्टेट के जो आपकी जुडिशियल डिस्पेंसेशन है तो एक्सेसिबिलिटी की मतलब होती है कि जैसे हम कहते थे इसमें पेंडेमिक के समय में एक्सेसिबिलिटी मींस health system should be accessible. A health system accessible की मैंने within the reach, whether within the 10 to 15 kilometers, which can be considered physical accessible. अब आप कार से accessible करने के लिए 500, 200 kilometers, that will not satisfy the definition of the physical accessibility. So accessibility means physical accessibility, the distance which is there. Availability, when availability की बात करते हैं कि वो the system should be available for everyone. कभी कभी होता है कि only available for a particular sections of the society, particular religious. So available means without following the principle of non-discrimination in availability, or all the facilities has to be there. And the last point which I said, affordability. Affordability means economic affordability. तो सिस्टम अगर लीगल सिस्टम में भी एक्सेसिबिलिटी, तो वो जस्टिस मदन लोकुर हैड, वी हैव नॉट कंप्लीटेड दैट पॉइंट. व्हाट ही said कि the local justice system or tribal justice system is popular largely because of एक तो unaware है, लोगों को पता नहीं, और पता है then they have no idea how far this convention system, the courts are there. There are not many courts, or their courts are located in the district, which like a villager has to travel at least in the 50 to 60 kilometers, and traveling, they are poor, they can't travel. So when they will go, and then somebody is there to loot him, the moment he reaches, some lawyers will be there, and then you have to pay. So it's like in the next door, I have somebody, uncle is there, or gaon buda, I go there with my disputes and discuss with him. So he gets accessibility, the affordability and availability, all formula applies to him, and he feels a happy end of the day. So he never makes a complaint. His problems are resolved peacefully in the village system, where he feels things are much easier, and that this same conventional with codified laws are not relevant for him, and he is not bothered about that particular part. So that is the reason what Justice Madan Lokur and we also agree. So when we look into that, no, customary law is also law, is according to Article 13, paragraph 3, and the other reasons we find why these courts are very popular in northeastern states. There are regions because they are still disconnected, they are still far away. The development, maybe development, when development takes a huge way, there's a possibility each system, each village system will start collapsing one by one. We have seen, we have witnessed, and you will see more changes in your days to come. We have seen how from the joint family will become a nuclear family. We have seen a family of 5, 6 considered reasonable family has to come to one. It will come to zero soon. So you see everything is like a change has taken place over there. There's no state involvement. State itself. Sanjay Gandhi has made a policy कि हम दो हमारे दो वो की तो 1974-5 में जब इमरजेंसी में उन्होंने हम दो हमारे दो, अब तो हम दो हमारे एक। तो ये तो सरकार का भी नारा नहीं है, लेकिन ये हमने खुद सहारा लिया, हमारे अपने डेफिनेशन आए, हमारे अपने अंदाज आए, तो चेंज हो गए। पहले सरकार ने दबाव में कोशिश करी थी, गवर्नमेंट वाज प्रेशराइजिंग, government was forcing to achieve the target, but without what people have already realized, for quality life. Now what you focus, a quality life to your children. You feel, how much you want. So even if a maid servant, she works, she thinks about the betterment of the children. आप बात करोगे तो बोले कि ये नहीं करना चाहिए, मैं जो कर रही हूँ, he should go. So they also did. It's not only the educated, even uneducated family, it has gone down. Children's number have gone down in all sections. Earlier 10 or 9, वो आप पूछो तो पता नहीं कि 6 हो गए, 7 हो गए तो पता, लेकिन now they have 1 or 2, they 2 or maximum 3. So quality of life becomes in the 21st century an important aspect, and that changes are taking place in the remote areas, and that may, as I said, in 50 years, the discussion will be an historical discussion, which we'll discuss in the second part. जब आप बताएंगे कि ऐसा होता था, ऐसे लोग होते थे, उस तरीके के सिस्टम करते थे. Let's complete with that. And he says कि Northeast India, another reason why the method of and what dispensing justice is in accordance with. Let me quickly start with, and then I'll continue and finish. The system of enforcement of tribal customs is very strong in the Northeast and is constitutionally protected. Full stop. Conventional courts, as we understand them, are very often out of reach for tribals in the Northeast. And that is another reason why the method of dispensing justice in accordance with customary law is so popular among the tribals. It is necessary. Now we ask, it is necessary for all of us to try and strengthen. It is necessary. So what the judge is saying, it is necessary for all of us to try and strengthen customary courts. So he says strengthen customary courts and enforcement of customary laws amongst the tribal communities. It is necessary for all of us to try and strengthen customary courts and enforcement of customary laws amongst the tribal communities, since the system of administration of justice, has been accepted, the system of justice has been accepted and practiced by them. Since the system of administration of justice had been accepted and practiced by them for centuries without any dissatisfaction with their delivery justice system. So it could, and that is very valid point which we have to do. System has no complaint. हो सकता है कि complaint, there are a lot of factors are also complaint because ignorance. Then belief, I have to live in this social conditions also. Power of the elderly person also in a mind. If I go something, say something, they may say, you leave the village for 10 days, 15 days, or you shift to another village. Lot of reasons are there. But it has both. It has good, it has bad also. So bad part we have to address. So this alternative mode of dispute settlement has to be encouraged. So even it's a form of the customary law. So customary law, so village dispensation of justice through the customary courts need to be revised, need to be, and there we have looked into one important aspect, the codification. Rest of the things will take little bit later. Let me come to the two part of the, there are a few provisions of the schedule 6 and schedule 5, which will give you the, but this is the like, no, it's not part of the customary. So it recognizes the village code, but it's like it's also given a structure who can be appointed, what are the, so like this has to be more on the constitutional framework. If we go look into the schedule 5 first quickly. So schedule 5 is not schedule 6 is more important for us, but schedule 5, what we have said, we have discussed the section 4 or paragraph section 4, it talks about the part B of the schedule 5. Part B of the schedule 5, it talks about the administration and control of scheduled areas and scheduled tribes. That is the like part B. And there, so schedule section 4 it talks about tribes advisory council. Tribes advisory council, and it says there shall be established in each state. So this is like so it's a constitutional. So you have their tribes advisory council. So section 4 says there shall be established in each state having scheduled areas therein a tribes advisory council. So like a tribes advisory council consisting of not more than 20 members of whom so each district should have a tribes advisory council. And what is the tribes advisory council duty? It goes elaborate, we don't need to go on there. The duty of the tribes advisory council to advise on such matters pertaining to the welfare and advancement of the scheduled tribes. So welfare is not adjudication, but this will be playing very important role in the welfare advancement of the state there. And we leave it there. There's nothing much there. Then we come to the sixth schedule. So we tribes advisory council, we say okay, welfare and advancement of the people, that is the function of the each district will be there. And it elaborates further governor role and other things. So we don't need to go in that one. So if we say okay, each district under the schedule 5, paragraph 4, tribes advisory council has to be there, and main function of duty of the tribes advisory council for the welfare and advancement of the people. We come back to the sixth schedule, and under the sixth schedule, it has a paragraph 2, which talks about the constitution of district councils and regional councils. And it says there shall be a district council for each autonomous district consisting of not more than 30 members there. And second paragraph says, paragraph 2 ka sub-paragraph, there shall be a separate regional council for each area. So regional council will be on top and then district council there. And then it goes into the other power and functions. So we don't need to go on all these things in the limited and leave it there. So schedule 5 and 7 is like we have seen some kind of role in the under the constitution, particularly for the tribal people. I'll take this later. Now we come back to the okay. I'll just write. I think I have written also. Paragraph 4 of the 6th schedule envisages or customary village council. Paragraph 4 of the 6th schedule, customary village council, codes in respect of law enacted under the part 3 and 4 of this schedule. जो भी लॉ लगेगा तो विलेज कोड्स की बात करते हैं पैराग्राफ 4 में. पैराग्राफ 5 of the sixth schedule confers power to district council to try suits and cases under CPC and CRPC. ये उनकी जो है. And as we discussed, the customary village council courts are generally made by chieftains of the tribe. जो भी वहाँ के जो चीफ होते हैं वो ज्यादातर जो कस्टमरी विलेज वाली बात वहाँ पे करते हैं, and who are assisted by village council comprising of village elders, जो गांव के बुजुर्ग होते हैं. जैसा मैंने कहा था आपको, गांव बूढ़ा इज वेरी फेमस इन अरुणाचल प्रदेश, इन गांव बूढ़ा, GOAMBURAS. ये वर्ड का आप किसी भी नॉर्थ ईस्टर्न से पूछिएगा व्हाट इज गांव बूढ़ा, व्हाट्स द इशू, they will be able to tell you. Arunachal Pradesh people will be. And then similarly in Dovasis in Nagaland, DOBHA SIS in Nagaland, Manipur and Nagaland. The customary village council code, both village council and code and regular code system are under this. So एक है इसमें are under the superintendence of the High Court of concerned state under Article 235 of the Constitution. So आप अगर नहीं खुश हो तो you can go before the High Court also, or other courts also. It's not necessary. So but what we have seen, so we have provisions. So like suppose some person approaches to the village council or village court for the redressal of his matter, and he is not happy. He had other options, but those options will be subject to economic capacity of that particular person, then capacity to challenge the established authorities in the village. तो आप अगर जब जाएंगे कि आप किसी काम से बहुत सारी चीजें होगा, तो capacity to challenge the established authorities कि आप गाँव बोला कि you are challenging, so that will create some kind of dissatisfaction. So पंचायत के जैसे normal situation है, पंचायत के decision becomes binding. कौन जाते हैं लेके सुप्रीम कोर्ट में और हाई कोर्ट में? It's like an NGO, public spirited individual. It's not the victim. Very rarely victim has gone. Even in Visakha, this is somebody else, an NGO has gone. So victim, so like all the cases, if you look into, it's not victim. It's largely because of the what Justice Krishna Iyer has done. Somewhere the opening of the door of the court to the public business litigation, and other judges equally contributed. But we see victims they are represented by somebody there. चाहे आज के दिन भी हो और पीछे के दिन के बात है, all the cases were represented by entire environment. MC मेहता का contribution है कि उन्होंने सोचा कानपुर टेनरीज का, बिलो टेनरीज की, all cases, कमलनाथ, everything MC मेहता has taken. नहीं तो हम उसी तरह धुआं में रहते, धुआं में जीने की एक आदत से बन गई होती. तो but you see a public spirited individual who has taken, and this is safe. There is a provision. If you are not happy, you can move out. But who will move out? अभी भी कहीं ना कहीं गांव में तो खास करके till date, हिंदी तो आप समझ सकते हैं ना सर? मैं हिंदी को थोड़ा यूज करना चाहता हूँ आजकल. मुझे लगता है कि हिंदी और इंग्लिश में थोड़ी सी बीच बीच में आप सबको भी करना चाहिए रेगुलर क्लासेस में, तो हल्का से ज्यादा नहीं, क्योंकि उससे हमारे वादी प्रतिवादी हिंदी के शब्द भी हमारे दिमाग में घूमते रहते. संज्ञान है ना, जो टीवी में हम सुनते हैं समय कभी कभी संज्ञान ली सका, तो संज्ञान का क्या मतलब होता है? कवि जैसे रहती है वादी प्रतिवादी, तो कभी कभी हिंदी पे हमें थोड़ी सी अपनी मातृभाषा की ओर भी, जस्ट लैंग्वेज में आप उड़िया बोलते तो उड़िया कर सकते हो, तमिल बोलते तमिल कर सकते हो. वी हैव टू लिटिल बिट. अगर तमिलनाडु में पढ़ाएंगे और बंगाल में पढ़ाते, बंगाल में से पढ़ाते, तो स्टूडेंट चाहे मैंने पढ़ाया तो ज्यादा समय क्लास के बाद तो बांग्ला में ही ज्यादातर बात करते. जब भी मैंने सर आपने क्या बोला तो लोकल से कनेक्ट भी होती है, लोकल भाषा से कनेक्ट होती है, और कम्युनिकेशन भी कभी कभी अच्छा होता है. तो दोनों चीजों का इनपुट करना चाहिए. So we come to the, so that is superintendence की बात होती है. Now we come to the some of the important cases which I have Chanchal has given, so I prepared this lecture, so I just thinking on that. So some of the cases we have looked into. Today, we look into the important part, and that is clearly reflected in the election of our president. So we always underestimate the power or the feelings or sentiments of the. कभी भी ऐसे thought नहीं आएंगे कि we always thought that scheduled tribes or like जो people है वो गांव में scheduled tribes. There's a difference between scheduled castes and scheduled tribes. There's a like similarity between the we have not used and we say कि it's indigenous people. So like worldwide it's known as a indigenous people. That is the aboriginal thing. Only in the Indian constitution we have used tribal people, but meaning is more or less same. So tribal people, they are shy in nature. They live in an isolation. They never have some kind of you might never you never noticed that tribal people are agitating on the street or any region. So कभी कभी कुछ हुआ हुआ है तो थोड़ा सा होता है. So they live in isolation, largely in the hills area. They have their own culture. They have their own. They're very shy in nature. It's globally. They are very shy in nature, and they don't want to interact with the outsiders. It was very difficult when Britishers entered and they gradually on the faith of them and they started education and what else other you can say, but they are doing similarly. So people have gone there. So they live in isolation. So their world is confined to that particular day. And that is the reason now Andaman Nicobar, Jorwa tribes, there are one region, so many islands are there. So government has completely prohibited. Without permission, you can't go. So there's some kind of also they say, why don't you want to bring them in the mainstream? They just say you are denying education, you are denying the development. But there are some kind of justification for both sides. One can see and examine. But government has to maintain their lifestyle, their way of thinking. They are totally protected, and their populations are declining day by day. So tribal population. So nobody enters there except government officials, in sometimes some help or something. So government authorized officials are permitted in some of island where only Jorwa tribes live because government has. So government believes in the respect their self-determination, their autonomy, their self-determination, autonomy, and other aspects, and that is what they say. So they are very shy. We have never seen. And when this opportunity has come, they have never struggled also. They were happy, whatever we're giving. So seats are there, 130 almost in India. If you seats like a MLA or MP seats putting together has an influence of the scheduled tribes people can play important role in them, and that is why this time, despite party line, many tribals and they're emotionally attached, they voted against the party line to the Honorable Draupadi Murmu. So they voted. The tribal people are there, so they become part of the mainstream. So we have to also understand how to bring them in the mainstream. And in the global level, we have that. In the global level, we have one declaration was adopted. United Nations Declaration on Right to Indigenous People. United Nations Declaration. So that is the main document. And अब जैसे इनको threat आ रहा है, बहुत सारे cases हैं, that is their land is taken by the government for the industrialization. So I said in the globalization there is a threat, and we have some of the judgment of the tribal lands are confiscated by the government because tribal peoples are living in the hills. They are living in a place where they believe they worship tree, they worship hills, they worship animals. उनका एक है, हम भी करते हैं. हमारे यहाँ भी ट्री की बने बहुत सारे जो बिहार यूपी में तो खास करके पेड़ों की पूजा होती, कुआं की पानी कुआं की पूजा, मैरिज के टाइम में बहुत सारे रिचुअल्स हैं that even in regular time also some of the trees are there in the in our even culture. So if somebody writes on the development of international environment or environmental law, we find a lot of references, protection of environmental, preservation of environment in our ancient texts. Those some of the things which we'll take in the later of how research is important. All right. So this convention, this declaration is a declaration. It's not legally binding. It's not a legally binding is there. And the country which has not signed, like not become a party because it's only one time. It's a declaration. You can join later. So they participated, but they did not. Very first day when 13th September 2007. 13th September 2007, I think. सर गलती कभी होगा तो माफ कीजिएगा उस तरीके में याद करके बोलते हैं 90 I believe कि 13 September 2009 but there is a purpose that time UN declaration on right to indigenous people was adopted. United States, Canada, New Zealand or one more country, they did not join only this particular declaration, which is only for the exclusively there. So most important thing, they have this convention, this declaration, which is non-legal binding instrument. We have to also, it's a non-legal binding, it's not legal binding instrument, but it holds a framework. अभी जैसे मैं बातें कर रहा तो Article 3, Article 4, Article 5 are important, and there are many others articles are there. So all three articles talks about the right to self-determination of the people, of the tribal people. So people, they have a right to determine their political status. कैसे रहना चाहते हैं और चाहे भारत के साथ रहना चाहते हैं अलग बन के, and also to pursue their economic, social and cultural rights. So they have a right to determine, they have full freedom. So state should not interfere. So what the state has to do, state has to respect that right. हम जब human rights की बात करते हैं तो we talk करते हैं state has to protect, state has to respect, state has to fulfill. So what state in the tribal people का है जो कि उनका अधिकार है कि वो खुद निश्चय करेंगे कि उनकी किस तरीके से आर्थिक स्थिति को बढ़ा कर किया जाए, कैसे उनके पॉलिटिकल सेटअप कैसा होना है, जुडिशियल सेटअप कैसे होना है, उसमें स्टेट का रोल नेग्लिजेंट, स्टेट को डिस्टेंस से बनाता है. स्टेट, जब हम ह्यूमन राइट्स की बात करते हैं, स्टेट हैज टू रेस्पेक्ट मींस स्टेट हैज टू रेस्पेक्ट आवर फंडामेंटल राइट्स. अगर कोई who violates our fundamental rights? State violates. State अगर आपको यहाँ से क्लास में हमें सबको पकड़ के ले जाए, कौन ले जाएगा? आप तो कोई वीसी मैडम तो नहीं पकड़ के ले जा सकती. तो कोई अगर पुलिस ऑफिसर आता है 5 आदमी को उठा के ले जाता है, तो स्टेट के on behalf of the state will violate your rights. So it says that no, state has to respect the rights, and the state has to. So state should not do any act which infringes the fundamental rights of the individual. So state की ये responsibility, आप ऐसी कुछ ना करें जिससे जो मानव अधिकार जो दिया गया है कॉन्स्टिट्यूशन में वो वायलेट हो. सो स्टेट शुड रेस्पेक्ट एंड प्रोटेक्ट. आप ये भी आपका दायित्व है, इट्स योर रिस्पांसिबिलिटी टू सी कि नो अदर इंस्टीट्यूशन, नो अदर प्लेयर शुड वायलेट द राइट्स ऑफ द इंडिविजुअल. इफ दे आर वायलेटिंग तो आपको प्रोटेक्ट करना. तो स्टेट हैज टू रेस्पेक्ट. सो स्टेट इज प्रोटेक्टेड and state is abuser. Same principle applies in the case of the tribal people. So tribal people have right to self-determination, right to determine their political status, the right to pursue their economic, social, cultural, legal, whatever you call. So वो बड़ी fundamental है, and that has been recognized globally also. इसी में एक दो बात और कहना चाहते हैं कि एक legal binding instrument, that is International Covenant on Civil and Political Rights. Okay. So International Covenant on Civil and Political Rights, it talks about the both rights. Both rights means जहाँ कॉन्स्टिट्यूशन में तो कुछ राइट्स हैं, इंडिविजुअल राइट्स भी हैं, कुछ आपको कलेक्टिव राइट्स है ना, माइनॉरिटीज के कलेक्टिव राइट्स है, लेकिन फ्रीडम ऑफ एसोसिएशन कलेक्टिव राइट्स है, तो वो कहीं इंडिविजुअल के नेचर में है, कहीं कलेक्टिव राइट्स है. सो सिमिलरली इंटरनेशनल इंस्ट्रूमेंट ऑफ द कवेनेंट, यूनिवर्सल डिक्लेरेशन जनरली इट हैज बोथ, but International Covenant on Civil and Political Rights, the very first article, it talks about the peoples have a right to self-determination. वो काफी कंट्रोवर्शियल भी हो गया, peoples have a right to self-determination, so people can decide. So हमारा कॉन्स्टिट्यूशन में भी कहते हैं कि peoples have a right, आर्टिकल 3 में आप कर सकते हो, परस्यू कर सकते हो, बट within the constitutional framework हम स्ट्रगल कर सकते हैं. So creation of the new state is through the constitution. So people struggle. Creation of Jharkhand is not is offered by the government. Creation of the last state, that Telangana, is a long struggle. So people decided, no, our aim, our interest will not be protected in existing system, or like, no, we need to be separated because there is some kind of difference exists between the mainland and us. And that struggle has led to creation of the state within a federal structure system, and then we have number of states. ये पंजाब आज जहाँ बैठे हो, one point of time it was part of the Punjab. So पंजाब से हरियाणा भी आ गया, पंजाब से हिमाचल भी निकल गया. So it's like some kind of struggle, some kind of some causes were there where people agitated, and that creation is just permissible. But this is what you have. You have internal self determination. अगर आप तो बात करते हैं तो इसको आप कहेंगे internal, so which is permissible. What is not permissible? External self determination. You don't like no state will allow to create a independent state from the mother state. So like the government of India अगर ये कहेंगे जैसे हमारे जम्मू एंड कश्मीर के झगड़े चल रहे हैं मतलब कि हमें अलग बोले कि तुम ऑटोनॉमी लो, whatever you want you take here. But the moment you say कि we want a separate country, that is not acceptable. So this particular issue, because this is a legal binding, so this is also under the International Covenant on Civil and Political Rights, what we have just discussed about the right to indigenous people. So right to indigenous people, 3 articles I said, 3, 4, 5, all self-determination aspect hai. अगर आप पढ़ोगे तो उसमें पाओगे. And then similarly in the human rights instrument also, Article 1 of the International Covenant on Civil and Political Rights also talks about the self-determination. It also talks about the right to self-determination. अब problem देखो कैसे बने, how politics plays very important role. So when since it's a legal binding instrument and it applies to all, including the states which have decided to accept the obligation. It's a voluntary. अगर government नहीं चाहेगी तो नहीं होगा. So government of India has also accepted the legal obligation. So government of India has decided on 10th April 1979 that we should become part of the International Covenant on Civil and Political Rights. So we voluntarily become part of the so legal obligation. There was no pressure, but we decided a new government, Congress government came after emergency and decided to become Janata Party till 79 Janata Party. So they decided to become part of the human rights instrument. So legal obligation is there. So when they have accepted the legal obligation, then people like you, they sit and they say this provision will create some kind of problem. Article 1, which talks about the right to self-determination. So government to save itself, government has said that Article 1 is not applicable to us. So government of India has made a reservation. So a treaty permits a state. If you want to become a part of treaty, that most of the treaty permits a state to make a reservation. If you find that certain provisions are difficult to apply, you accept, but you are not accepting the entire convention as a whole. You say that there are 2-3 provisions, which I said in the pseudo Article 5 for the discrimination, like the customary practices. Same here, Government of India has said, and what the Government of India has made an argument. We respect the right to self-determination. So as a principle, they said we respect the concept of right to self-determination. So we believe in the right to self-determination. However, this concept should apply only against the colonial states. If a state has been colonized, not for the newly independent country. So we have already, because we struggled for the right to self-determination, we got the independence. Now, again, you don't say like we are not colonizing anything. So only against if a colonial state exists, any colony, the people are fighting, then we acknowledge the right to self-determination. So we are not diluting their concept of right to self-determination. However, we believe that it should not apply for the newly independent countries. If it applies in the newly independent countries, it will dismember large states, including United States and other states also. There will be problems. That is the reservation part is there. The another point which is very interesting in the future, like I'm bringing, is like a case was filed before the monitoring body, which is available under the International Covenant on Civil and Political Rights. किसी को पता है क्या है monitoring body? Who teaches human rights? So International Covenant on Civil and Political Rights is a legal binding instrument. So legal होगा तो enforcement की बात होगी. जब legal की बात होती है तो enforcement की बात होगी. Enforcement की बात होगी तो कोई monitor करेगा, कोई supervise करेगा. जब supervise करेगा तो उसके पास power होनी चाहिए, complaint भी हो कि आप हम कंप्लेन भी फाइल कर सकते हैं। ये सारी बातें उम्मीद करते हैं जहां कानूनी बातें कुछ रहता है तो इन चीजों का होना समावेश होना चाहिए कि क्या आप फाइल कर सकती हैं कंप्लेन की नहीं, कि आप क्यों क्या प्रक्रिया है कंप्लेन फाइल करें, ये सारी बातें हमारे माइंड में आता है। तो जो भी इंस्ट्रूमेंट लीगल बाइंडिंग है तो उसमें इन्फोर्समेंट मशीनरी होती है उसके अंदर में, कि ये बॉडी जो होगा वो सुपरवाइज करेगी, मॉनिटर करेगी। तो आईसीसीपीआर जैसे आपका सीडो ही देखते हैं, महिलाएं हैं यहाँ पर, तो जैसे सीडो की हम देखते हैं, सीडो में भी एक कमेटी है, कमेटी ऑन द एलिमिनेशन ऑफ ऑल फॉर्म्स ऑफ डिस्क्रिमिनेशन अगेंस्ट वुमेन। सो कमेटी जो है वो रेगुलर नहीं मिलती है, लाइक नो इट्स नॉट सिटिंग एवरी डे, दे मीट 2-3 टाइम्स इन ईयर। Like Indra Jaising, it was the last member of the India. So 23 members are elected for the committee on the elimination. This committee looks into the how states are implementing its obligation under the CEDAW. Also, committee examines the complaint. कि कोई महिलाएं अगर कंप्लेन डाली है उनके पास, तो दे हैव पावर टू रिसीव ए कंप्लेन एंड गेट एंगेज विद द स्टेट कंसर्न। सो इंडिविजुअल कंप्लेन को भी उनको लेने का अधिकार है कमेटी। तो कमेटी जैसे उसमें है उसी तरीके का इंटरनेशनल कॉवेनेंट एंड सिविल एंड पॉलिटिकल राइट्स में ह्यूमन राइट्स कमेटी इन्फोर्समेंट के लिए, जो आप अगर कन्वेंशन खोलेंगे आर्टिकल 28 to 45, जैसे आप 1 से 6 तक जाएंगे तो ऑब्लिगेशन अदर थिंग्स है, 6 से 27, 6 to 27 ऑल राइट्स, यदि वुमन हो गया कि क्या क्या अधिकार है, क्या राइट टू लाइफ किस आर्टिकल में है, प्रोविजन अगेंस्ट किस में है, राइट टू पर्सनल लिबर्टी किस में है, जुडिशियल। सो 6 to 27 talks about the rights, individual rights and group rights also in the 6 to, but at the moment after 27 जाएंगे तो then you enter the another chapter which says कि to implement these rights a monitoring body will be constituted which is known as Human Rights Committee. फिर 28 से 45 if you read, then you will find power functions of the, जैसे भी हम लोग ट्राइब्स एडवाइजरी काउंसिल के तो पावर एंड फंक्शंस ऑफ द ह्यूमन राइट्स कमेटी क्या वो कर सकते हैं। वहां 18 होते हैं, विल बी 18 members sitting in the human rights committee and they also like justice Bhagwati, he sat as a member of the committee। वो हम लोग के समय में था, तो बहुत पहले उनका 12 साल तक he represented India in the human rights committee. He sat as one of the members. India was representing 3 consecutive times in the Human Rights Committee along with 18 members. So बहुत सारी जो बातें होती थी तो बहुत सारी कमेटी में हमारे भी रिप्रेजेंटेटिव रहते हैं, इलेक्टेड होते हैं, they sit there. तो जस्टिस भगवती served longer period in the Human Rights Committee on behalf of the India represented. So many cases उनके सामने भी आएगा। हमारे यहाँ से केस नहीं जा सकता है, उसके कुछ कारण है, उसके और पहलू में वो नहीं बात अभी एक्स्ट्रा कंट्री से है। तो ह्यूमन राइट्स कमेटी ही सब, तो कमेटी इज ए मॉनिटरिंग बॉडी, कमेटी वो मॉनिटर करती है सारा चीज। अब कमेटी के पास एक समस्या आई, कमेटी स्टार्टेड रिसीविंग कंप्लेंट। तो एक ट्राइबल सोसाइटी जो बहुत फेमस केस है, मिकमाक ट्राइबल सोसाइटी वर्सेस कनाडा। मिकमाक MIQ चेक कर लेना, मिकमाक नाम तो ठीक है, स्पेलिंग में गलती हो सके, MIK बट मिल ही जाएगा। मिकमाक ट्राइबल सोसाइटी वर्सेस कनाडा। अब कमिटी के पास ट्राइबल सोसाइटी हैज फाइल्ड ए केस एंड दे वांटेड लॉट ऑफ इश्यूज विद दिस कि देयर राइट्स आर वायलेटेड। This case and subsequent cases, there are a couple of cases, not many cases. There are like early days. There's this case and number 2, 3 or more cases were appeared before the committee. Committee found it's very difficult because it involves right to self-determination, and they have filed the case under the Article 1. Right, peoples have a right to self-determination. They did not on the individual. They said the tribal community has a right. Our tribal community has a right. So you invoke the Article 1. Committee had a tough time because the moment committee gives, like had committee given or deliberated anything on that issue, it would have displeased the concerned state. So बहुत सारी चीज डिप्लोमेटिक है या पॉलिटिकल, so legal issue also। कल ही एक बात हो रहा था एक कॉन्फ्रेंस में, जस्टिस रविंद्र भट्ट थे और जस्टिस और ये परवीन आनंद थे। So Parveen Anand had said one thing he just informed all of us in the meeting in this seminar that Justice Bhatt has told him long time back. There's a difference between the lawyer and judges. So what like the point is that judges they look into not only the case before him. He looks into the social, economic, political, and other aspects also before delivering judgment. So facts of the case is there. That is the source. But he examines the other aspects also. So like that is the reason we look into the all aspects. It's not the only the legal issues. क्या implication होगा, क्या response हो सकता है, which those points are also considered. Okay. So what we hear Human Rights Committee also considered simply what kind of implication if we start taking, there will be no end. People will come right to self-determination today from Canada, tomorrow from India, from other countries will come. So the committee has a difficult time. And what committee has done, you see, committee had said, and that is the reason I said, first we said in this case, the petitioners, the person author, so complainant is known as here under this author. So our company asked the author whether, in what capacity you are representing. Big Market Travel Society, you filed a case, what capacity you are. So he said, I'm filing in the individual capacity. I filed on behalf of the society. That committee looked into whether you have been authorized by the committee, whether the society has authorized you to represent them or you have come on their own. So lack of authorization. So they're looking for something. Lack of authorization case was this one. It did not discuss detail. And what committee finally closed, committee said that now onwards, after three cases, that committee jurisdiction will start from Article 6. Individual rights, right to life, not on the collective rights, because collective rights is right to self-determination. It's people have a right. It's not people have a right for the clean environment. People have a right for the sustainable development. People have a right for the self-determination. And that is the concept. The people have a right for the clean environment, no problem. Supreme Court will study. But Supreme Court will hesitate to study a case where people have a right to determine their political status. That court will have a tough time to look into that part. Or that case will be pending like other cases which could generally 6-7 years, refugee cases, CA cases, 370 cases, that those cases will never ever open. Sometimes by the time Chief Justice he'll take in the last moment, then gave the constitution of bench, half of the judges will retire. So sensitive issue, court also look into that particular part. So you see that even right to.
So, but doing so, they are not diluting the right to determination, right to self-determination.
So I said no.
So they have diluted.
Yeah, I diluted. They completely ignored. I'll not say they completely said. They said now the jurisdiction starts. So they decided that our jurisdiction. So we will not entertain. And why they will not entertain? Because it has, the existence of the committee will also be in question. How committee runs? Committee runs by the state. Who are there? You are there. So you are representing India. Somebody is representing Australia. Somebody is representing. So they are not representing. Though they weren't there, they are not representing their country. In that sense, you are not representing your country. You are member of the committee. But you can't, government, once you return, and they all are holding double position. So they are university professors, they are judges, because it's a ad hoc body. So government will say, what is happening? Why you are just so there are a lot of issues there, and that is the reason they thought it's not to continue. They closed. It's not that they answered. They closed the debate relating to the invoking the jurisdiction of Article 1. You can use Article 1 with Article 27, minorities, freedom of association, minorities rights. So when you club Article 1 with the other rights, that is going on. But exclusively depending on Article 1 along with the other rights, permissible. Article 1 exclusively, they said, sorry, we don't want to go into that controversial area. So they were more wise decision, I say. But that is it's not European Court of Human Rights, which has more independence, more freedom to decide on there. Let's complete with the some of the cases which I have done for you. We start with the phase, though it's not directly, but Samta versus State of Andhra Pradesh. That is 1997. Later on also 8 SCC 191. Samta, SAMA THA versus State of Andhra Pradesh. 8 SCC 191. A constitutional bench held, in this case, a constitutional bench held that land in government or private hands, could not be transferred for mining purposes, to non-tribals in fifth schedule. So, अगर private के पास भी कोई land है और ये, that could not be transferred to there. That is the there. And then court says the fifth and sixth schedule constitute an integral scheme of the Constitution. The fifth and sixth schedule constitute an integral scheme of the Constitution with direction, philosophy, and anxiety to protect the tribals from exploitation and to preserve valuable endowments of their economic empowerment, to elongate social and economic democracy with liberty, equality, fraternity, and dignity of the person in our political Bharat. So, so this is the term that cannot be. But the next case, which is contrary to the first one, is Balpo Employee versus Union of India. This is the 2002 case, 2002 to SCC 333. The court held that granting of a mining lease to Balco in a scheduled areas of Chhattisgarh was permissible. So they contrary, what would they say? Chhattisgarh was permissible because it was governed by the law of Madhya Pradesh or not Andhra Pradesh. So it will not follow. So you were governed by this, so that's the change. Then the another case is related with the District Council of, this is the third, District Council of United Ghasi and Jantia Hills, JAIMTIA, Jantia Hills versus Cityman Savian, SITIMAN. 1971 bracket में 3 SCC 708. The court held the district council acted beyond its jurisdiction. So the court held 1971 3 SCC 708. The court held the district council. So district council, what we go back to say, district council acted beyond its jurisdiction in passing a law governing the transfer of land to non-tribals, comma, since the schedule only reserved rights over land use. So what the power is given to the over land use, occupation, and allotment, not its transfer. District council can do land use, occupation, allotment, but not transferring to the non-tribal there. Quickly we'll do so. Another is the District Council of the Jowai Autonomous District. District Council of the JOWAI Autonomous District versus Duet Singh, DWET, Rymbal, RYMPL. This is also old case, 1986, 4 SCC 38, 1986, 4 SCC. The Supreme Court ruled that while the district council has the right under the 6th schedule to levy taxes on lands and buildings. The district council has power to levy taxes on lands and buildings. But it had no right to extract royalties on timber from private forests. But it had no right to extract royalties timber from private forest or land under its jurisdiction. We come to the last, that is also very important case. There are many subsequently also, but these are the cases which I thought I'll discuss. Odisha Mining Corporation Limited, जो अवतार सिनेमा से हम कभी कभी करते हैं, नियमगिरी हिल्स की रिलेटेड. So this case is actually Odisha Mining Corporation Limited versus Ministry of Environment and Forest. Very good case, like no one can look into. 2013, 6 SCC 476. It relates to the mining on the Niyamgari hills of Odisha. Not very encouraging. The court held that the state government has the ownership. The court held the state government has ownership over the mines and minerals deposits beneath the forest land, and that the scheduled tribes and other traditional court held the state government has the ownership over the mines and minerals deposits beneath the forest land, and that the scheduled tribes and other traditional forest dwellers, other so उसको कहते हैं TFDC, traditional forest dwellers, traditional cannot raise any claim or rights over them. The state government has the power to reserve any particular area for bauxite mining for public sector corporation. But it recommended, so finally, that the Gram Sabha be directed to consider whether the bauxite affects the religious rights of scheduled tribes or other forest dwellers. So it also recognized government, but like some way say that religious rights of Gram Sabha kitne kare. These are the points which I wanted to discuss, and just to laugh because that is in the 2016 standing committee on this particular issue which we have discussed is there. Standing committee on personal public grievances. They have made some suggestions with their. हमने discuss किया quickly मैं करूँगा functioning of the current tribal justice system. One point. The committee, so government, the parliamentary committee. The committee noted that the most tribal communities prefer the tribal justice system. पहला बात हमारे conclusion हुआ है. Tribal justice is preferred tribal system. So this is in 2016 because of their familiarity with customary laws. Because of their familiarity with customary laws. Second, हम सब बात discuss किए. Minimal procedure and cost effectiveness. Minimal procedure and cost effectiveness. And third, timely delivery of justice. Now, what are the challenges? The first, it says the challenges in the functioning of the current. So preferences we have got. Every tribe within a state had its own customary practices. Every tribe within a state had its own customary practices of dispute resolution. One, challenge. Second, most of the judicial decisions were not written down. Most of the judicial decisions were not written down. And give the tribal chief wide discretion. So the job bottom should discuss. And thus it results in sometimes punishment for the same crime vary from person to person. Now come to the second point. This we are functioning of the current. So we have preference, why and why, what are the changes we have challenges. The second is the issues with regular justice system. And they, because first they like the tribal justice system, they don't prefer. The first thing is they don't prefer the regular justice system because what we have discussed, expensive, lengthy, and follows complex procedure. Expensive, lengthy, and follow complex procedures. A large number of tribal population has not been exposed to mainstream justice delivery system. And the parliamentary committee recommend that parliament may enact a law to set up a tribal justice court system. उसके बाद हमें ये नहीं करना है कोई separate high court करो. The last point, synergy between tribal and regular justice. So what, like, there need to be clubbing, bringing synergy between the tribal justice system and regular justice system, tribal justice system. And committee suggests the providing necessary infrastructure, judicial officers, or codification and other things are there. I think with this we end. So lastly, we say that this tribal justice system is preferred, popular, and the reasons we have, and we have also discussed there is a possibility of, we also noted, which we did not discuss, is not written, there is a possibility of personal bias of the gaon budha or elderly person who educates. So there are issues that are there, but why it is preferred? Because inexpensive. Most important. It's not involving complex procedures. आप भी कोशिश करते कि कहाँ इसमें फंसना है, लोग चाहते किसी तरीके से बातों को सेटल करो. मीडिएशन में हम अपने जगह कोई प्रॉपर्टी कहीं झगड़ा हो या कुछ हो तो फर्स्ट होता है कि we try to look into that. So these are the issues. The best way it has to be a little bit bring closer to the regular justice system. With this, I end here and I thank Dr. Chanchal, Dr. Mithile, our colleague Sutus, all of you. Thank you very much.
Thank you, sir. Sir has meticulously examined the interface between tribal and regular justice system. Whatever question we have, we will investigate those questions next session because it is time for lunch. Thank you so much.